The prior lessons gave you an overview of the discovery process and introduced you to the tools of discovery. Interrogatories, requests for production of documents, and requests for admissions are other effective discovery devices. After this video, you should be able to define interrogatories and list their advantages and disadvantages, explain the purpose of requests for production of documents, and describe the uses of a request for admissions. Interrogatories are written questions submitted by one party in a lawsuit to another party in that suit. The party responding to these questions must answer in writing and under oath. Rule 33 of the Hawaii Rules of Civil Procedure regulates the use of interrogatories in Hawaii State Court. Rule 33 makes clear that the type and amount of evidence that can be sought is much broader than that which could be produced at trial. Under the rule, no more than 60 interrogatories, including subparts, can be propounded on any party. However, multiple sets of interrogatories can be served on parties to the lawsuit as long as the number of interrogatories do not exceed 60. The purpose of interrogatories is to obtain information about the basic facts in a case. It may also be used to determine the party's contentions and identify specific individuals or documents that support the opposing party's contentions. Similar to deposition testimony, interrogatory responses can be used to impeach witnesses at trial in the event they change their testimony. Interrogatories may also facilitate a settlement in a case. Interrogatories offer substantial advantages over other discovery methods. They are simple, inexpensive, and efficient. Interrogatories may be more thorough than depositions because the party responding must answer and verify the information. In addition, they are under a duty to obtain the answer if that information is in either the possession or the control of that party. The responding party also has a duty to provide the identity of the person who does have custody of a document if the party does not have it. A final advantage is the fact that interrogatories complement the other discovery techniques. Some of the disadvantages of using interrogatories is that they are limited to the parties to a lawsuit. Therefore, you may not serve interrogatories on third parties. They also do not eliminate the need to take a deposition at a later date. Interrogatories also lack spontaneity, as the person responding has 30 days to ponder the question and submit a response. Similarly, due to the 30-day response time, interrogatories do not allow for immediate follow-up questions. Follow-up questions can be drafted and submitted, but this does not eliminate the possibility of further self-serving answers. Another disadvantage is that interrogatories may help the opposing party to the direction of your case. Despite these disadvantages, interrogatories are an effective discovery device. Paralegals are often asked to participate in drafting interrogatories. Before you can draft an effective set of interrogatories, you must take the time to familiarize yourself with the facts of the case. To do this properly, review the pleadings, the correspondence file, the attorney's notes, the research notebook, and information provided in the initial and subsequent discovery disclosures. Your review should be as active as possible. Take notes as you review the material and consider the types of questions you will want to ask the other party. The format that you use in drafting the interrogatories will be mandated by federal or state rules. In most jurisdictions, including in Hawaii, interrogatories should contain the title of the document, instructions for responding to the interrogatories, specific interrogatories to be answered, a signature block for the attorney to sign, and a certificate of service. Several types of interrogatories may be asked. Each of these are designed to elicit a different form of information related to the lawsuit. These special interrogatories include interrogatories to identify people, interrogatories that establish facts or lead to discovery of facts, interrogatories that identify documents, and interrogatories that identify contentions. Care must be taken in drafting questions because discrete subparts are counted separately. As soon as you receive a set of interrogatories, You should contact the client and forward a copy of those interrogatories to the client. The deadline for responding to interrogatories is normally 30 days after the interrogatories were received. Most interrogatories cannot be answered quickly. Therefore, you will have to consult with the client to determine whether the time allowed is realistic. If you and the client conclude that more time is required, your attorney should request an extension of time to respond. It is important to respond to the interrogatories in a timely fashion because failure to respond on time may waive the right to object to the interrogatory. When answering the interrogatory, the answers must be made in writing by the attorney or the client under oath. If after answering the interrogatory, the party learns that the response given was incomplete or incorrect, the party has a duty to supplement the information and submit a supplemental response to the request for answers to interrogatories. Objections to interrogatory should be served with the answers and asserted appropriately in the response. Some of the objections that can be asserted in a request for answers to interrogatories include attorney-client privilege and medical and confessor penitent privileges. A party may also object to the interrogatory on the basis that the interrogatory calls for inadmissible or irrelevant evidence, is overbroad, vague, or unintelligible, is unduly burdensome, or calls for information subject to a confidentiality agreement or protective order. This is a page from a sample request for answers to interrogatories. You will note here at the top, you have the caption, the introductory paragraph, and then the interrogatory itself, and a space for the answer. Now let's talk about requests for production of documents. A request for production of documents is a formal request that a party in a lawsuit provides specific documents or other physical evidence to the party making the request. Before drafting a request for production of documents, you may want to locate sample requests for documents online or in your firm's document management system. Of course, no two cases are exactly the same, so you will have to modify any form or sample request to fit the particular facts and issues in your case. Document production often involves many parties and several requests. Similar to requests for answers to interrogatories, your draft document should include the title of the document, definitions, instructions, and the specific documents you're requesting to be produced. When responding to a request for production of documents, objections can be asserted on the following bases. The requests call for the production of attorney-client privilege communications. The documents are protected by the work product doctrine or other privileges, or the requests are overbroad, contain duplicative requests, or call for irrelevant evidence. When responding to requests for production of documents, although the paralegal and the attorney will be drafting the response, the client should be actively involved in producing the documents responsive to the request. You should work with a client representative that is coordinating the document collection efforts on behalf of the client. Once the documents are produced by the client, you as a paralegal are responsible for organizing the document production. You will need to control the documents, copy and print them, scan them into your document management system, number the documents, and label them. Consult with your attorney to determine what labeling system he or she would like to utilize. It is important to also keep the documents in the same order it was kept in the client's ordinary course of business. In addition to a formal request, documents may also be obtained in response to a request for a party to bring documents to his or her deposition. A party may also issue a subpoena ducis tecum for a non-party to produce documents, or may request them in connection with a request for answers to interrogatories. However, the most efficient and effective way to obtain documents is through a formal request for production of documents. This is a sample of a request for production of documents. You will notice here you have the caption, introductory paragraph. There's usually instructions that go between the introductory paragraph and the actual request themselves, but you'll have the request here as well as the signature. In Hawaii, these documents should be double-spaced, but this example is a single-spaced document, so please take note of that. Now that the discovery process has been nearly completed, you may need to establish the truthfulness, accuracy, and genuineness of the evidence that you and your supervising attorney have compiled. For that purpose, you may need to file a request for admissions. A request for admissions asks a party to admit to the truthfulness of some fact or opinion. It's also used to authenticate the genuineness of a document, and similar to requests for answers to interrogatories and requests for production of documents, requests for admissions cannot be served on a non-party. A request for admissions is a request filed by one party in a lawsuit on another party in that lawsuit asking the second party to admit to the truthfulness of some fact or opinion. The primary purpose of the request for admissions is to simplify the lawsuit by reducing the number and nature of the points in the controversy. The simplification creates a ripple effect, resulting in fewer witnesses, lower costs, and early settlement of the case. The request for admissions also emphasizes important factual information buried in volumes of documents. Requests for admissions are typically used to authenticate the genuineness of documents. They also confirm the truthfulness of facts and opinions and verify the proper application of the law. Some of the advantages of the request for admissions include the fact that the request cannot be ignored. The request has to be denied, otherwise it will be deemed admitted. The request can also be made at any time prior to discovery cutoff, and unlike requests for answers to interrogatories, there is no limit on the number of requests a party can make. The form and content of the request for admissions is similar to the request for production of documents and request for answers to interrogatories in that the request consists of a title and introductory paragraph, definitions, instructions, and specific requests. Responses to the request for admissions include admit, deny, or object. If a request calls for the party to admit or deny information that is deemed confidential or privileged, then an objection can be asserted. Examples of the various objections include the attorney-client or work product privilege, and medical privilege and confessor-penitent privilege. Another basis to object to the request is that the request calls for inadmissible or irrelevant evidence, is overbroad, or contains a compound request. Here is an example of a page from a request for admissions. You will note that this is a page taken from the middle of the document. It starts with request number 91, here's request number 92, request number 93. But in all of these requests, it's asking the party to admit or deny certain information related to the case. Now let's discuss project number 4, the request for answers to interrogatories. Review project number 4 memo and supplemental materials located in the Resources folder, project number 4 subfolder. Based on the pleadings filed in the Bennett v. Rickards-Haley matter, draft a request for answers to interrogatories using the template provided. Thank you for watching today's video. As always, please feel free to email if you have any questions, and please also proceed with completing this week's activities. Thank you.